The sources of American law. American law comes from a number of sources. We can think of these sources as being arranged in a hierarchy. The Constitution is the supreme source of law and cannot be overturned by any of the other sources of law in the system. Next in line are statutes. Statutes must conform to the constraints of the Constitution, but cannot be overturned by administrative regulations or the common law created by the courts. Administrative law is a step below this, with a narrower authority for rulemaking. The courts round out the bottom of the hierarchy, as they have a very limited area of authority for autonomous policymaking. The Constitution is the source of law that we're probably most familiar with. It began as a series of revisions to the Articles of Confederation, but the framers soon realized that a completely new foundational document would be required. The Constitution that resulted was the product of much compromise. The most important part about the Constitution, for our purposes, is that it creates a framework for the rest of the laws of the land. First, it sets out the procedural rules through which federal laws can be made. This process is familiar to you from your 101 course. The Constitution creates a Congress and tells us how to staff it. It stipulates that both houses of Congress must pass laws and that they must send the laws to the President for his assent. If the President vetoes the law, the Congress may override this veto by a 2/3 majority vote in both houses of Congress. But the Constitution also lays out significant substantive limits on the lawmaking powers of government. First, the Constitution gives a list of enumerated congressional powers and allows Congress the authority to pass only those laws necessary and proper to achieving the goals laid out in Article 1. Additional substantive limits were added to the Constitution in the form of amendments. For example, even if a law follows all of the proper procedures, it is still not valid law if it violates the First Amendment's proscription on laws that violate the freedom of speech. And the Constitution is at the top of the hierarchy because it is very hard to change. Laws of Congress cannot overturn provisions of the Constitution. The Constitution can be amended by one of the onerous processes laid out in Article 5. Goodness, we're still working on passing the Equal Rights Amendment that Alice Paul first submitted to Congress in 1923. We're so close. But the only other way to really change the Constitution is not to change its words, but to change how we interpret the existing words. Consider the Eighth Amendment's prohibition on cruel and unusual punishment. Perhaps cutting off a convict's ears might have been considered acceptable at the time the Eighth Amendment was ratified. But if we as a society rethink the meaning of the phrase cruel and unusual punishment such that it now precludes ear amputation, we might not allow the government to mete out this particular punishment anymore. The words of the Constitution haven't changed, but the interpretation has. The Constitution is the supreme law of the land, despite the fact that it has a mere 4,440 words. It is the shortest constitution of any major national government, but most Americans know only 3 of the words. One last note about constitutions. The American states also have their own constitutions. State constitutions lay out the procedural mechanisms by which state laws are created. While they are relatively similar to one another, there are some pronounced differences. For example, Nebraska's constitution is the only one that currently prescribes a unicameral state legislature. Some constitutions provide additional individual rights above and beyond those protected by the federal Constitution. For example, in the wake of the controversial decision in Kelo versus New London, the Nevada Constitution was amended to provide stronger protection against eminent domain. This makes it harder for state entities to take land from private owners for public use. Nevada's constitutional protections go beyond what the First Amendment provides. Our state constitution erects an even stronger line of separation between church and state, and it explicitly protects the liberty of conscience, even though they spelled it wrong. The second source of law in the hierarchy is statutes. Statutes are laws passed through legislative frameworks established by constitutions. Statutes are laws enacted by lawmakers. Federal statutes are enacted by Congress, and state laws are enacted by state legislatures. States also give authority to their localities to pass ordinances pertaining to certain facets of local governance. So, if you turn your television to CCTV4, you're likely to find local government in action, or inaction. But lawmakers must abide by the limits placed on them by their place in the hierarchy. So a city council will not be able to overturn a state statute, just as a state statute will not be able to overturn a properly conceived federal statute. And a federal statute cannot overturn a provision of the federal Constitution. And lawmakers must also abide by the substantive restrictions. Since the Bill of Rights has been largely incorporated to the states, none of these lawmakers may pass laws that abridge the fundamental substantive limits contained there, such as the freedom of speech or the equal protection of the laws. While the Constitution is relatively brief, we have all sorts of laws in this country. There's actually not really a count of how many federal laws there are, mostly because it's not clear exactly how we should go about counting them. The Office of the Law Revision Council puts out the United States Code, which is a summary of most federal laws organized by subject matter. This code takes up 54 volumes and includes more than 42 million words. Check out uscode.house.gov to see what's in those 54 volumes. This is not required reading for the course, by the way. The next source of law is administrative law. Administrative law deals with the power of the various parts of the executive branch to implement the laws passed by the legislature. So administrative law is basically the rules of the bureaucracy. Typically, Congress will delegate particular authority to the bureaucracy in order to clarify congressional statutes and turn them into precise rules that citizens and organizations will be able to follow. Their authority is typically derived from Congress, although Congress cannot delegate its core legislative duties to the bureaucracy. This is the source of the often maligned regulatory burden. At more than 200,000 pages, the rules and regulations in the Federal Register provide detailed instructions on how the bureaucracy interprets and intends to apply the law in practice. Another source of administrative law is the President. The President can issue executive orders. Most of the time, we can think of these executive orders like other kinds of administrative law, where the President gets authority from an act of Congress. In these instances, the executive order is the President's way of clarifying how he and his administration will be implementing the law. But sometimes executive orders are more like statutes. This happens when the President is not acting on the authority of Congress, but on the powers vested in him by Article 2 of the Constitution. Of course, whether the President has that authority is sometimes a matter of debate. The executive order shown in this picture is the so-called travel ban, signed in the early days of the Trump presidency. When it's not clear whether the President has the authority claimed in an executive order, it can land at the doorstep of our last source of law, the courts. The courts are lowest in our hierarchy of laws. The courts have very little space for autonomous lawmaking. Our courts are bound by the issues in the cases that come to them. They also tend to be sitting ducks for lawmakers and presidents to criticize. But more on that in another video. Courts are low on this lawmaking hierarchy because their primary source of power is the interpretation of the other sources of law. In other words, much of their work is to clarify the meaning of statutes in the context of an actual set of case facts. So then, of course, we might wonder why we should care about the courts. Well, although their power to make law is limited, their power to interpret the law is expansive. Indeed, the courts are the ones who interpret the Constitution. The courts are the only ones who can fundamentally change the meaning of the Constitution without going through the incredibly difficult amendment process. In this way, you might say that judges are bound by the Constitution, but the Constitution is whatever the judges say it is. I guess they get the last laugh.